record. All right, so 3, 2, 1.
Hi, everyone. We'll get started right at 12:30, but I just wanted to let you know as everyone was joining that we have a couple of moments. So again, as more of you join, we're just going to wait till 12:30 exactly and then get started. All right, seeing as it's now 12:30 and we're mindful of your time, we'll get started. Thanks everyone for joining us today on this Lunch and Learn. The seminar will be focused on tips for preparing your claim for litigation in the context of primarily tort claims. However, I know that there are some people on the call today that also do accident benefits work, so I will try to also provide some tips for AB claims handling as well. So as many of you know, Strigberger Brown Armstrong is a civil defense firm with offices in Toronto, Kitchener-Waterloo, and in London. Our lawyers practice in a wide range of areas, including bodily injury claims, accident benefits, fraud, property damage, cyber and privacy litigation, to name a few. For those of you who don't know me, my name is Laura Emmett. I work out of the London office. And as you can see in terms of this presentation today, if you haven't participated in one of these before, there is a chat function. So if you have any questions, we'll be doing a brief question and answer period at the end. So feel free to put the questions in at any point. The video will also be recorded, and so if you at any point have to step away, you can always know you can go to our website. So let's get started. So today we are going to be talking about 4 broad topics. So first, the scene of the accident. Second, the circumstances. So looking at a little bit more on a broader side, the plaintiff/claimant, and then early resolution of the file. So the question you get when you get a claim is, what can you expect? And so for most of you, I'm sure that you get a notice letter early on, you're informed of the accident, and then it's a long waiting period. And it could be up to 2.5 years or longer if they're a minor. And so there are certain things that we want to discuss today to give you the best possible chance of defending the file if it goes to litigation in the future. and trying to, wherever possible, avoid protracted litigation. So let's get into it and first talk about the scene. So step one, when you're notified of the claim, one of the first steps will be having a call with your insured. And so during that initial call, it's really important to find out if your insured took any photographs or anyone in their vehicle took any photographs of the vehicles involved, of the scene, perhaps of the plaintiff, really anything in the general area of this accident. And if your client says yes, then it's really important to get a copy of those photographs. I can't tell you the number of times where I've been sitting down to prepare a client for a discovery or an insured for a discovery, and they tell me, oh yeah, I took photographs, but nothing happened for 6 months or a year, so I didn't think I needed the picture anymore, so I deleted them. Or I had them, but I got a new phone and I didn't upload them to the cloud, and now I can't get them. And so it's really important to try to get copies of those photographs right from the beginning so that they're in your file. Obviously, depending on what the issues are in dispute, photographs from the scene can be highly persuasive to a trier of fact. So for instance, in one file that I had, the plaintiff and the occupants of the vehicle described the accident and the impact as being an explosion. And our insureds fortunately had taken photographs of the damage to the vehicle, and there was basically none. All that there was a slight scratch where there was the imprint of the license plate screw on the plaintiff's vehicle, and there was absolutely no damage to our insured's vehicle. And so when those photographs were disclosed, it did, the plaintiff lawyer did, take a step back in terms of what their view of the case was, because they had this objective evidence. And then when you're talking about photographs, another question that you should ask is whether there is any dashboard camera evidence. And usually if someone has a dash cam, they're going to disclose that information, but it's obviously a stressful time for them and they might forget. So important to just make that inquiry. And again, for the same reason, if you have dashboard video of the accident, it can be highly persuasive to a jury or a trier of fact. Unless it's your insured that caused the accident, in which case you have the evidence and it's not as helpful for your case, but at least you know exactly what happened. So at that time of the initial call, if your client is saying that there really wasn't any damage to the vehicle, to their own vehicle, you might still want to ask whether they could take some photographs so that you have that evidence preserved as well, or have someone from your company or a third party investigator go out and take photographs for, again, the same purpose. And by the same token, if the accident is very serious, you need to determine whether you should have the vehicle inspected. And obviously there could be a property damage file, but do you want your vehicle inspected by an engineer or an investigator to preserve evidence in case you have to get an expert report down the road, if the black box evidence is going to be very important, and particularly where you're dealing with an extremely serious accident where it could be over your insured's limits, you want to make sure that you are preserving all of the evidence necessary for an engineer to prepare a report down the road. Third, you need to decide whether you should be sending out an investigator or someone from your company to go out and actually take photographs of the scene of the accident. Obviously, Google Maps is great, but it doesn't tell you about what that scene looked like on the day of the accident or within days of the accident. So it's not going to show what the construction lane closures looked like, or if there was something in the general vicinity of the accident scene which impaired someone's ability to see down the road. So I had a file where it was a very, very serious accident, and the police attended. They prepared a TCCI report. One of the co-defendants said that their ability to see down the roadway was impacted by corn that was very high. And although the police took literally hundreds of photos of the scene, they were all taken at night. And so we had no photographs of what the actual corn looked like. So we couldn't be able, we weren't able to verify what this co-defendant was saying. So having those contemporaneous photographs, or photographs within a couple of days of the accident, would have been very helpful, particularly if there's any type of discrepancy between the various parties involved in terms of what the scene looked like. And then the fourth is social media posts. And what I'm talking about here is that sometimes, we're seeing more and more in our culture where people are taking photographs and posting it to Twitter of an accident scene that they're not involved in, but it's a way to connect with people. I'm not sure, but they post these photographs, which could be helpful in identifying where vehicles were, etc. And I recently had a case where the police actually did a walkthrough of the scene and posted it on Twitter because they were trying to remind people how dangerous it is in the summer months with motorcycles on the roadway and people not paying attention. And so from experience, it's way easier to find those social media posts in the days or weeks after the accident than it is 2.5 years later, where you're trying to guess what keywords might trigger a post. So next, on to the circumstances of the accident. And the first thing that you should be considering is whether to obtain a statement from your insured. So you have that initial interview where you get the basic information about the accident. And then do you go out and actually get a signed statement or a recorded statement, or is a summary sufficient? And so when you're deciding which route to go in, consideration should be given to the fact that what happens if your insured subsequently passes away? It's obviously more helpful to have a signed statement or a recorded statement of exactly what how the accident happened than it would be to be just relying on log notes and a summary of a brief phone call. And so that is a key consideration, and factors such as the seriousness of the accident, the potential exposure, are things that you should be factoring in. And then with respect to witness information, and I guess, sorry, just in terms of the statement from the insured, what's really important is that you're getting as much information about what happened immediately before the accident. So where they were coming from, if they were in a rush, if there were people in the vehicle, had they consumed any drugs or alcohol. Then about the actual mechanism of the accident itself, if they made any observations of the plaintiff, is there anything that the plaintiff could have done that they didn't, or conversely, they did do, which made the accident worse? And then what happened after the accident, speaking to witnesses, police involvement, ambulance attendances, charges that were laid. And it's important, if you're doing these statements, to not be too married to your script and really just listen to what the insured's saying to you. And if you have any questions, making sure that you clarify those small details, because the small details could be really key. So next, it's important to identify any potential witnesses in terms of liability or damages, and getting the contact information from those witnesses and trying to arrange an interview, either with someone from your company doing that interview or hiring a third-party investigator to go out and get those interviews. In terms of identifying witnesses, obviously speaking with your insured, speaking with opposing counsel if a lawyer has been retained, to see if they're aware of anyone, and then reviewing the police report to see if there's any witnesses identified on that. And as obvious as it might sound, sometimes we don't think to get the correct spelling of the witnesses' names, which can go a long way, particularly if, on the eve of trial, or, 6 months or a year before the trial, the lawyer that you retained is trying to locate these witnesses and their phone number has changed or their address has changed. And so having that correct spelling does help us try to locate these witnesses. And then as you're getting your statement, reviewing the scene, interviewing witnesses, you need to be determining whether there is anyone else that should be brought into the litigation or potential litigation. And if there is someone that you think shares in the responsibility, it's important to let plaintiff counsel know of it as soon as possible. And the reason why is that you want them added as a defendant in the statement of claim. Yes, you can, at the end of the day, after you've been sued, third party that company or entity in. But the problem is if the limitation has been missed and the plaintiff can't name that person in their statement of claim, then you have to be along for the ride, because the only way that they can get access to that third party who shares in responsibility is through your third party claim. So it can complicate matters. And yes, there is, this whole discoverability. If the plaintiff wasn't aware that there was someone else responsible for the accident, then that could extend the limitation period. But why go and have to have that battle at the end of the day when you might know about a potential liable party 6 months into litigation? So share it and then avoid the complication of litigation. Next, moving on to the plaintiff / claimant. The first and obviously very apparent way of finding out information about a plaintiff or a claimant is conducting a social media search. Obviously, there's some great information, candid information, either about updates on what's going on in their life, videos that they post, or photographs. And if you are obtaining that information, then it's important to, or reviewing that information, it's important to preserve it so that when litigation happens and you send it to a lawyer, that they're able to see what's been posted. But in a lot of cases, we see that plaintiffs change their name. So, instead of being Laura Emmett, it's just Laura Leanne. And so if we have photographs from Facebook posts that we can use to cross-reference that it is in fact the same individual, then that is helpful to us. Online searches are also really helpful, and that would be, seeing if there's other information about the claimant online. So for instance, I had a file where the claimant was a runner and they did marathons and 5Ks and all of these crazy distances before the accident. And in the 1.5 years after the accident, they did multiple races. And so fortunately, my client downloaded that information and I had the race times. It was very similar both before and after the accident, although they said they couldn't do any runs. But had my client not have preserved that information and downloaded it, I would never have been able to access it again, because the website went defunct and it was no longer available once I was retained about 2 years after the accident. So helpful to download and keep copies of that information. And then along with that, in terms of online searches, not everyone thinks about the fact that YouTube can be a treasure trove of information, both in terms of liability, because there might be the police posting a video from the scene or someone else posting a video from the scene, but also of the claimant doing things. So again, I had a file where the claimant was an inspiring dancer and musician. And so in the examination under oath that I conducted, he told me that he couldn't lift one of his arms above shoulder level. And meanwhile, on more than a monthly basis, he was posting new videos of himself dancing, and his hands were above his head on almost 90% of the videos. So again, very persuasive, because in front of a trier of fact, they can watch the 5-minute video month after month after month of him dancing and not appearing to be in any obvious distress. So another place to look. And then examinations under oath obviously are very helpful in the context of accident benefits claims, but there is, especially if there's some overlap in terms of the issue. So if you're on the tort side dealing with an OPCF 44R and the issue is residency and dependency, then having information or potentially attending the priority dispute examination under oath, where similar information is being shared, might be helpful in assessing your exposure on the file. So if you're looking to proceed in that fashion, probably likely to, or recommended to speak with a lawyer about it to ensure that there's no implications of you asking to participate, but it is something in terms of thinking outside the box on how to get relevant information at an early stage. And then surveillance. Obviously, like social media, it's very helpful to have video of a claimant or a plaintiff in their everyday life in the months following the accident. And sometimes, you get phenomenal evidence. And if you do get that, then we would recommend getting more of it, because the more that you can show that the claimant's life hasn't been significantly altered as a result of the accident, the more persuasive it will be for a trier of fact in the future. Money spent on this, particularly if it's good, is money well spent. And then if you're hiring a surveillance company to conduct surveillance, also consider whether they should be doing a social media search to preserve the social media posts. It's easier to use, instead of just screen captures, to have the actual page preserved. It makes it easier at the end of the day at trial in terms of admissibility. And then finally, requests for production. So use Section 33. Section 258(3) of the Insurance Act also allows, in the tort context, the production of information. And so use those resources available to you to get relevant information quickly so that you can be assessing your file. One thing to keep in mind in terms of requests for production, particularly again, if you're dealing with the 44R and the issue is residency and dependency, is that some records, the address that's listed changes depending on an update. So if the claimant at the time of the accident was living with their parents and then 6 months later moved to a different place, if they report that address change to the bank, all the records, even going back to the time of the accident, will show the most up-to-date address. And so that could be important if you're able to show in the month after the accident, they were living somewhere else, and then it changed, that is helpful. So bank records, school records, those are two that definitely change depending on where the claimant is currently living. And then the last topic that I want to discuss in the couple of minutes that we have left before moving to questions. So again, if you have any questions, feel free to include them in the chat. But the first in terms of early resolution would be to produce your client for an early interview. And by this, I mean, and I have two files where I have CCTV of the accident. We can see that our insured was not responsible for the accident, and yet plaintiff's counsel was not prepared to let us out of the action until they spoke with our insured to get any other collateral information that would assist in their liability investigation. So we agreed to an informal discussion between the plaintiff's lawyer and our insured, and I was there, and the plaintiff's lawyer asked the questions, identified who they, what they thought was the key issues in terms of which vehicle in a multi-vehicle accident was responsible for the collision, and then they let us out. And so I didn't even have to file a defense because it really was just the plaintiff lawyer trying to get as much information as possible. Again, we would recommend exercising caution when you're dealing with this and speaking potentially with a lawyer about what the implications could be, but it definitely could result in an early resolution of your file. And then if you have good relevant documentation, so surveillance, social media posts, liability investigation information, witness interviews, disclose that information, and it might result in you being able to settle the file on an earlier basis without incurring legal fees. And then finally, just consider whether you can discuss settlement and resolve the file. And I'm sure many of you do. Try, but if you've marshaled all of this great evidence in terms of liability and damages in the year and a half before litigation is threatened, or the statement of claim is drafted, then it makes it easier to settle the file early on. So with that, I'm happy to take any questions that anyone has. And just as people are thinking of any questions that they might have, what I'll do is I will just mention the upcoming two upcoming seminars that we have. So on March 31st, there will be a minor injury a guideline update, reviewing the recent trends. And then on April 6th, there will be a summary judgment motions and occupiers liability claims seminar. So I don't believe that there are any questions. I'll give it one more moment, and then otherwise we will let you go and you can enjoy your day. But again, a reminder that the webinar will be posted on our website. And if you have any questions that you think about after we've disconnected today, please feel free to reach out to me. And if you want a copy of the slide deck, then please let me know, and I'm happy to send it. So with that, thank you so much for attending. SBA appreciates your ongoing support of these seminars. And have a great day.